The Supreme Court just made history. Well, at least 8 of them did. Last night, May 4th, the court issued a follow-up order. The Calais appellees, so that's the Louisiana residents who challenged the unconstitutional map, they asked the court to waive the normal 32-day waiting period before the ruling gets transmitted to the lower court. So normally there's a month-long window after the Supreme Court makes their ruling before the ruling goes into effect. The plaintiffs in this case wanted that 32-day waiting period waived because Louisiana's May 16th congressional primary had already been suspended by Governor Jeff Landry in order to allow the legislature to redraw the new map. So they wanted this ruling enforced in time for the midterms, obviously. Because if it's not, then 2 unconstitutional districts would continue to exercise influence in Congress. So the court granted the request. They waived the 32-day interim period. Again, obviously, right? Why wouldn't they? It's a ruling that by the nature of the timeline of our elections would require it to be enforced immediately. Pretty straightforward, you would think. Not according to Ketanji Brown Jackson. Nope. Justice Autopen, in a solo dissent, joined by literally nobody on the court, not even Kagan or Sotomayor, Justice Autopen erupted. She wrote that the court's order has spawned chaos in the state of Louisiana, and she accused the conservative majority of abandoning principle for power. She actually accused the 6 conservatives of trying to interfere in the midterms by not allowing for the normal 32-day waiting period, even though the other 2 liberal justices agreed to suspend that very waiting period. And of course they did. The decision just rendered Louisiana's racially gerrymandered districts unconstitutional. So of course they can't enter the midterms with those 2 unconstitutional districts in place. But according to Justice Autopen, that's exactly what Louisiana should do. And if you interfere with those 2 now unconstitutional districts, you're being partisan. You are interfering in an election, and that is blatantly politically motivated. And after that obvious temper tantrum from Justice Autopen, Justice Alito he heard enough. And he was done with it. He was joined by Clarence Thomas, Neil Gorsuch, and Alito penned a concurrence that addressed Jackson's charges and said blatantly, quote, they cannot go unanswered. One of her points was trivial at best, and the other was blatantly baseless and insulting to the court. Now, keep in mind, this is a published permanent legal opinion. That published permanent legal opinion just referred to a fellow Supreme Court justice's charge as basic nonsense. It was baseless, it was insulting, and it was utter nonsense. Alito went on to say that Jackson's accusation that the court abandoned principle for power was a groundless and utterly irresponsible and frankly reprehensible charge. And he pointed out how was her demand that these districts, now rendered unconstitutional, any less a partisan play than what she was accusing the conservatives of doing.